Good morning and good afternoon to everyone, and thank you for joining our webinar today on TCPA compliance, marketing versus informational calls and text messages. My name is David Wang. I'm the VP of Marketing here at TrueDialogue. Today's presentation is brought to you by TrueDialogue and VoiceShot, who provide cloud-based communication solutions to over 3,000 combined clients today. TrueDialogue's SMS products and VoiceShot's inbound and outbound voice platforms are both industry leaders and service hundreds of different verticals. Now on to some housekeeping items. All attendees will be muted during the presentation, and if you have any questions, please enter them in the Q&A section and we will get to as many as we can. If we don't get to your question, we will reach out to you personally to answer them. This webinar is being recorded and we will send you the recording within 24 hours. Our speakers for today are Jon Right. He is the CEO of TrueDialogue and VoiceShot. And we are also joined by our special guest, Adam Bowser. He is a partner attorney at Aaron Fox in Washington, D.C. Adam specializes in the area of consumer protection and privacy with a focus on TCPA. The agenda for today will include an overview of TCPA and how it relates to voice and text messaging. Then we'll get into some of the types of messages that businesses can send to their customers and the regulations for each type, along with some examples. And then we'll go into some compliance tips and then end with Q&A with Adam. So with that, I'll go ahead and hand it over to Jon.
My name is Jon Right, and as David mentioned, I am the CEO of TrueDialogue and our sister company, VoiceShot. I want to thank, number one, Adam for joining us today. One of the biggest questions that we get asked by our customers, both at VoiceShot and TrueDialogue, are compliance related. We found Adam 4 years ago, and once we had kind of talked with numerous TCPA attorneys, we found Adam to be probably the most versed, well-knowledged, and also I think the fact that he's never lost a TCPA case bodes well for his reputation. He basically takes people who didn't do their kind of fundamental research and understand the rules and regulations and the playbooks that you need to operate out of for making voice calls or text messages and get into some type of issue. It's a heavily debated topic. There's a lot of gray areas. Adam has helped us internally help our clients, and we're happy to bring him here to speak with you about many of these topics today. So thank you again for your time. Adam, I'm turning it over to you.
Well, thanks, Jon, and thanks everyone for joining us today. It's not that complicated of a field. I kind of like to describe it as, 15 minutes can save you $15 million. So this is really just hopefully going to give you the tools that you guys can succeed and spot the issues for what you need to know. Because again, the compliance is not particularly complicated. But just to get into the TCPA, which stands for the Telephone Consumer Protection Act. That was a law that's been it's been on the books since 1991. The Congress passed it, and they essentially handed it over to the Federal Communications Commission, the FCC, to implement. And so it largely regulates telephone calls. There's still some faxes out there and text messaging. So there's essentially two big components for telephone calls in the TCPA. There is what's called subsection B, which is going to be the kind of the rules and regulations surrounding the use of autodialers or pre-recorded voice. And that's a very dynamic topic in terms of whether your equipment is in fact an autodialer. These days, the law is in fact breaking fairly favorably in a lot of jurisdictions, but we're just going to assume for this conversation that you're using an autodialer, and what would you need to do if in fact you are using an autodialer. But again, just keep in the back of your mind, there are other defenses out there if we could always bring to bear. But on top of that, there's also pre-recorded voice restrictions in subsection B as well. Then there's subsection C. And so I just want everyone to understand that that's really the do not call provisions of the TCPA. Those are separate and apart from the autodialer. So it's really just, those rules are pretty easy to comply with to the extent that you're not cold calling and you're basically only contacting people who have, expressed an interest in your business, have inquired, or with whom you have an established business relationship, or have provided their prior express consent. And you're basically monitoring do not call requests if you are telemarketing, which we will really get into. But turning back, to the history of the TCPA, it was really designed to go after the nonstop telemarketing, telephone solicitations, really, that were happening at the dinner hour for kind of unrestricted telemarketing to the home, which everyone was just viewing as a very big invasion of privacy. That expanded in 2003, where the FCC, really just on its own motion, folded in text messaging to the TCPA, and really just for all intents and purposes, a text is a call. There's really not, really any distinguishing characteristics for text other than, it's not a pre-recorded voice call, so you don't need as many, there's not as many regulations applicable to it in terms of disclosures, but everything else equal, a text is considered a call. And so the way the kind of TCPA is structured in terms of enforcement, it's largely enforced by private plaintiffs. And so it's probably, in the top 5 of types of cases that are filed across the country. It's because of it's a whole cottage industry of TCPA class action attorneys that, find one plaintiff and then, will just file a cookie cutter complaint saying on information and belief, we believe that, this company has done this to thousands of other consumers. And so that's, really how it's enforced. You have the FCC has separate authority to enforce it with even larger fines, but by and large, it's a, sort of private attorney general statute where the plaintiff's attorneys, will try to collect $500 or $1,500 for knowing or willful violations, essentially treble damages. They will try to collect that, on a per message basis. So obviously, it's just mathematical, and so you can get fairly absurd levels of damages fairly quickly. I believe there was a $1.2 trillion case filed in California a few years ago. But again, it's just the number of messages times 500 or 1,500, so it can get pretty large pretty fast. In terms of the TCPA in latest updates, it's an interesting area because it's always in flux. But thankfully, there's been quite a few circuit court level, so one level below the Supreme Court. There's just always been debate about what is an autodialer. Is one of the big issues in the TCPA. So I won't get into the weeds in those, but the 7th Circuit, the 11th Circuit, and previously the 3rd Circuit have all gone back to the basic statutory language, which is, does the system itself have the present capacity to randomly or sequentially generate numbers and to dial those numbers? That's the real statutory test. And pretty much any modern dialing platform doesn't randomly or sequentially generate numbers. People are contacting curated lists. So that essentially means that in quite a few jurisdictions, embracing a lot of states, you're not going to be using an autodialer. And that has other benefits in terms, and which we'll get to later, in terms of covering your downside risk. So that allows you to select forum clauses or choice of law provisions in your mobile terms and conditions that allows you to really protect yourself by not only adding in class action waiver provisions with arbitration clauses, but you choose the law that's the most favorable. So those are really helpful developments lately. This is just within the last few months where the 11th Circuit and the 7th Circuit have ruled. And then on top of that, or separate and apart from the autodialer issue, the Supreme Court will be just very recently coming up where they're going to be hearing remotely for the first time oral arguments on whether the TCPA itself should be struck down because there are essentially clauses that Congress added in to collect government-backed debts. And the 4th Circuit in Virginia had ruled that it's an unconstitutional, essentially favoring some speech over others. And so the question before the Supreme Court is whether the whole statute should go down the toilet or whether they can strike these new provisions about government-backed debt. And that's a whole constitutional issue that we won't really get into on today's call, but it's interesting. But for by and large, it's not the more meat and potato type of compliance issues that pretty much everyone on the call I think is concerned about. Getting into the actual mechanics of how the TCPA approaches varying types of communications, there's essentially three recognized categories in the TCPA. There's going to be marketing communications or telemarketing, which is going to be regulated the strictest. Then there's going to be informational, which if it requires consent, it'll be the middle ground consent. And then there are emergency messages, which are expressly accepted from the statute, meaning that the TCPA there's no consent. It's just emergency messages are thrown out of the statute because they're the types of messages Congress did not want to restrict. And now the fourth category, if there is, separate, it's really the hybrid category where you could be, combining informational and marketing in the same message. And the rule is just really you have to round up to the more restrictive type of message. So generally speaking, marketing is going to be, are you encouraging someone to purchase a product, good, or service from you or on someone else's behalf? There's going to be, again, assuming we're in autodialer land, which again, it's not a safe assumption, but just address it from a consent perspective, because consent essentially cures everything or takes care of everything. If you have the right consent, you don't need to worry about whether you're an autodialer or not. So really what the consent rules are you need prior express written consent from the consumer before you start sending them telemarketing messages. And that is not a complicated type of consent. It's really two sentences that you need to present to the consumer in a kind of clear and conspicuous way before you start sending telemarketing messages. And so what you just need to do in that prior express written consent language is you need to inform them that they're agreeing to receive telemarketing messages from, using autodial or automated technology, or if you're using pre-recorded voice, you tell them that. And it's going to go to this particular telephone number. You have to identify who you are, who the seller will be, essentially, and you have to disclose to them that consent is not a condition of purchase. So again, this is all upfront. It's a good way to view it is kind of a clear and conspicuous disclosure, kind of a checkbox option. If you're thinking of how you update your Apple software, you basically have to go in and click I agree. So that's what the FCC expects. They expect consumers to take affirmative action after seeing the clear and conspicuous disclosure that they're agreeing to it. So again, two sentences, checkbox, and then you're really off to the races from a kind of minimal compliance perspective. And again, this can be really any type of electronic method that you can opt people in this way. It can be physical forms, it can be web forms, it can be in response to call to action displays in a restaurant, university campus, or anywhere that you have a display where they can text a specific keyword in to your shortcode program, or even email response. So you have a lot of flexibility in how you obtain this prior express written consent. So again, the examples are legion, but really what we're just going for, what the quintessential marketing message is that there's not an existing sale that we're talking about, something the consumer has already agreed to. So what we're really talking about is the expectation or the hope of a future transaction. And so this week only get 15% off all oil changes, drive through contactless oil change in 15 minutes or less. You are promoting a sale that has not happened yet. And so that this would easily be viewed as a telemarketing message. And so again, to the extent that you're using an autodialer, you would want to have the prior express written consent before sending that text message to the consumer. So again, you can't slide in kind of sneaky marketing messages in otherwise informational text. So this is what, kind of the example that I wanted to caution folks about, where it's a hybrid where you kind of have to round up. If you're, half the message is informational, but the other half is going to give them a coupon for a future purchase, you're going to view the whole thing as telemarketing. You can't slice and dice messages like this. So informational messages, let's take a step back. So in 1992, when the FCC implemented the first TCPA order, what they essentially, they didn't have a telemarketing informational distinction at that point. So really what they said at that point was, and it's a bit of a misnomer, but what they said constituted prior express consent, which is what the statutory term is. It essentially was, it's satisfied by the consumer voluntarily disclosing their telephone number to the company who's sending the messages. So that satisfies, since 1992, that has been the standard for prior express consent. It wasn't until February 2012 where the FCC adopted a different standard for telemarketing, and which took effect. The FCC gave industry 18 months to come into compliance. So it wasn't until October 16th of 2013 where there were effective rules distinguishing between telemarketing and informational. And the FCC was very clear in its 2012 order that the rules were not changing for informational text messages. And so the standard is that if a consumer in any way, really just voluntarily discloses their telephone number to you, either orally in writing, they have consented for the purposes of receiving informational calls. And again, that's assuming it's autodialed text to a cell phone. You do not need any type of consent to send informational autodialed or pre-recorded voice calls to landlines. So if you're, if you have a church or your school system, or you're calling landlines at a dorm, you don't need any type of consent for a pre-recorded voice call or anything it's informational in nature. And so again, informational would be just you're not trying to sell anything first and foremost, but it's you're providing information that really is about your existing relationship. And so even though it can be commercial in nature, it's not necessarily telemarketing. So a good example would be, I go to Lowe's, I get a special order, I haven't fully paid for it yet, but they send me a notification that my package has arrived and I should come to the store and pick it up. That is informational, even though I haven't really closed the deal, so to speak, on paying for it yet. They're just letting me know that my existing transaction with them, it has arrived and I should come pick it up. So nothing to increase or enhance the consent level there. Again, just if you have just released your telephone number, that's the only consent you need. And so, again, the basic assumption is that consumers want these messages and they don't want to overly restrict that, those types of communications. In any type of form, you don't need magic language. I just want to reiterate that you don't need magic language, for informational communication. So if you have just, website, contact information that you're capturing and there's a phone number in there, to the extent the person has voluntarily disclosed that as part of, you don't need, we are going to autodial you even for informational. You don't need to have those disclosures. So it's really a safe way of contacting people as long as you are voluntarily getting their telephone number. So just an example of that. So you have a local gym, which we all probably haven't seen in a couple months now. But if they send out a message, this week's classes have been canceled, you can access our video library here. This is an existing relationship. The gym patron has released their telephone number. So there's nothing that you need to do special to send this message after having that person voluntarily release their telephone number to you. So again, it just conveys message about the existing relationship. So it would not be considered telemarketing. And, helpful tips you can provide, again, this is just the gym saying, get your week started off right with these diet tips. You're not promoting anything there. The gym's not promoting anything there that would, result in someone engaging in commerce. You're just providing a free, useful resource, to the customer. Once again, the customer's voluntary release of their telephone number is sufficient. So as we stated at the top, emergency messages are just categorically excluded from the TCPA. So anything that is going to impact the health or safety of the recipients, and there's no bright line, I think, test, and we want to get information out there to the extent that it's going to affect people. Again, it could be companies, your Dominion Power or whoever your power company is, that basically says, hey, power is out. People that are on dialysis or anything like that, they need power. So that could present a clear public safety hazard. And obviously in the middle of the pandemic, there's going to be a lot of information that we want to get out to the public that should be considered an emergency. Again, the assumption is we're not going to restrict that in any way. Emergency messages are categorically excluded. So again, you really just have to think of what the general test is, and the test is it a message that's going to impact kind of an immediate health and safety of the recipient. And so an example could be our campus is closed this week due to heavy snow. We don't want people traveling in snow to risk their safety. And if you're canceling school, that's going to be an emergency message. So no prior consent needed, but presumably you probably already have it if you're contacting people on a list. But you're just doubly safe for trying to get these messages out. And so just to recap, you can't get sneaky with trying to sneak in informational messages. There was a kind of, just to give you an example, there was a somewhat famous TCPA case for this in the Ninth Circuit on the West Coast, where Best Buy was alerting people that their Best Buy reward zone points were expiring. I think it's a bad case, badly decided, but what the Ninth Circuit essentially ruled was that essentially you are, even though it's seemingly informational, that you are alerting someone that their Best Buy reward points are going to expire. The implicit message, at least, was that you wanted that person to come in and use them to buy, a product there with their points. So that really just kind of highlights where things can get a little dicey, is where there's going to be you're trying to encourage someone to actually purchase something that they haven't agreed to purchase already. So that's where you really just need to just play it safe and say, well, this person hasn't asked for this. Let's just assume it's going to be telemarketing. And if I'm using an autodialer, I would need their prior express written consent. So again, the basic rule is that if it falls into two categories, telemarketing or informational and emergency, please don't combine telemarketing with emergency messages. But if there's any type of overlap, you always round up to the one that requires more consent. So there's another example on the next slide. So this is one way where companies may want to just kind of increase engagement, where they try to conduct a survey. That the first part is informational. Please rate your recent experience 1 to 5. But if you're going to send them a coupon for 10% off, you're going to be encouraging the purchase of product, good, or service through that coupon. So the whole message will be considered telemarketing, in which case, again, you'll need their prior express written consent. So, just going back to kind of the overall health check on, TCPA, where it's going, the litigation is dropping off, thankfully, because of the more favorable rulings in large swaths of the country. So you're not going to see, like, the Southern District of Florida was a huge hotspot just because of sunny weather and a very big nucleus of TCPA bench attorneys. But the 11th Circuit shut that down, and so you're seeing a significant drop in filings there, as well as the Northern District of Illinois was a big hot spot. And then when the 7th Circuit released its autodialer decision earlier this year, the litigation has dried up there. So you're seeing a significant decrease across the country, but it doesn't mean that you still have the 9th Circuit. The 2nd Circuit just recently ruled, kind of adopting the 9th Circuit. So we're not out of the woods yet on the autodialer litigation, but by and large, nearly all of these cases that are being filed are going to be telemarketing messages, or there's the other flavor is debt collection. But assuming we're not in debt collection land, really the telemarketing messages are going to be the driver. No one's really filing a significant amount of complaints about non-telemarketing messages. So that's really because there's the case law around purely informational messages and emergency messages are pretty well defined, and as long as folks know the rule of the roads and you're getting at least someone's voluntary release of their telephone number, you're going to be safe. So then just be mindful of the hybrid messages. If there's going to be a path to a sale that they haven't agreed to, then you just want to play it safe and assume that you need their prior express written consent. Just good hygiene practices for TCPA compliance is just identify yourself, have a clear and easy way for folks to opt out. That really gets into the type of revocation cases where someone says they tried to opt out but they couldn't. But certainly, if you drive them to text stop, and I know True Dialogue makes it incredibly easy for whether it's P2P or even the texting platform, they make it very easy just to recognize stop requests in any type of messaging. So you just want to do that and recognize opt-outs and just honor that. And then keep a record of your opt-ins and opt-outs. Whether you have consent is an affirmative defense in TCPA litigation. And what that means in practice is that you have the burden of establishing that this particular individual that may have brought a suit consented to the text. So you have to prove that this person opted in through either you have a website record, a forum record, an opt-in, some sort of just method that you capture consent. It's going to be yours to prove. And then on the DNC, there's been a slight uptick in that type of litigation, where the way the rules are written by the FCC, it says it's unlawful to engage in telemarketing at all unless you have a do not call policy in place, you train your employees. There's a lot of defenses for that, but the easy way to just address that is have a simple policy saying this is how we recognize opt-out requests, and this is how we train our employees to recognize and record such opt-out requests. But again, that would be just if you're telemarketing. If you're just sending informational text, the DNC rules do not apply to you. And then everything I just said is about basic compliance. But if you want to turn your term paper from an A to an A+, this is where you want to start thinking about poison pills. Again, these are not legally required to comply, but if you really want to nip litigation in the bud, this is where just thinking about the process flow and having terms and conditions with class action waivers and arbitration provisions, including selecting the most favorable law, that's where you want to, that's where you can really protect yourself fairly easily by just having some simple, mobile terms and conditions that you present to someone when they're opting in. So there's going to be some, if folks are familiar with the CTIA, if you're using a shortcode or plan on using a shortcode, they're going to have basic requirements that you have terms and conditions and a privacy policy for your mobile alert program. And so they're very basic though. And so what I really recommend folks do is take that opportunity and expand it, where you put in, maybe a 2-page of additional legalese where you're presenting someone with, ultimately it's a click-through agreement that they have to accept to join your program. No one's going to read it in practice. They're just going to click through it and agree. But what that will do is it'll give you just tremendous amount of protection, because not only is that individual person going to be agreeing to it, but even if there's a dispute of whether that person actually agreed, you're going to be covered by everyone else that signed up the same way. So what that means from a class action defense perspective is that we're not going to have a class, because everyone else is going to be without standing. They're going to have, essentially they can't be class members in a class against you, because they have agreed to arbitrate all of their claims. So the bottom line is that you can have just, compliance is very easy. You get the disclosures out there, you get the consent. But if you want to really bulletproof it, you can just easily adopt a terms of service that the consumer has to click through to protect you even further. So that is maybe a little bit more than 15 minutes to save you $15 million, but that's the overview right there. So I'm happy to be put on the spot here and address some questions.
Thank you, Adam, for the great information. I think it really cleared up a lot of confusion when it comes to TCPA regulation around the different types of messages that businesses can send. So really appreciate that. So we have several questions coming in, and I'll start with the first one. Do you need separate opt-ins for both voice and text messages?
You do not need separate opt-ins. The only way, this is kind of like, it would fall into the shoot yourself in the foot category, where if you're going to be, again, this would only be applicable to telemarketing, because you need the prior express written consent. But assuming, let's take informational as an example. If someone goes to, Lowe's and releases their telephone number, and Lowe's doesn't shoot themselves in the foot by saying, we're only going to do this with your number, then you would have the ability to text or call that person just by their voluntary release of their number. Same thing applies to telemarketing. If you can certainly get the broadest consent possible up front to cover both voice and text, where you just said you just present the disclosures that you're agreeing to consent to receive autodial telemarketing text messages or phone calls, and then you would have a combined send, and then you're off to the races to send telemarketing messages, whether voice or text.
Okay, so our next question is, does every type of message that you send need an opt-out disclaimer? This is where the message includes, stop to stop. Does every type of message need that on every send?
This is actually an interesting question, and it's an area where a lot of my clients get tripped up on. And so the TCPA, which is the federal law, really governing these types of messages, are what controls from a legal perspective. So what the TCPA requires is just the prior express written consent language up front before you text someone. And then you have to honor opt-out requests, reasonable opt-out requests. But in terms of actual message disclosures, so when people see this message and data rates may apply, text stop to stop, help to help, that is not any type of legal requirement. That's a CTIA, the Wireless Carriers Trade Group, where they're having their own industry guidelines for use of shortcodes. So what that means is that no one can sue you for not saying text stop to stop in every message. So I just want to make that clear to everyone that that's not a legal requirement. The carriers can audit you, but the basic industry guidelines are that you have to present those opt-out instructions to the consumer if you're using a shortcode up front when they join. You have to present it to them in the call to action display, then in the opt-in confirmation message, and then the carriers want that text stop to stop disclaimer periodically. And what that means is that you have to include it at least once a month if you're operating a recurring messaging program. So you don't have to, but certainly you can include it if just to be on the safe side. But it's in no way a legal requirement. And then just from an industry guideline perspective, you have to do it at least once a month.
Thank you, Adam. We have another question here. We're going to kind of switch off a little bit, but This is from one of the education attendees. If a current student opts out or withdraws consent of a voice and text messages, are we still able to auto dial a voice or text to them to let them know that a term is starting or an assignment is due? Something that would be considered informational.
Well, so if their consent or really it would depend on the context of their opt-out. And so if there's nothing limiting their opt-out, you want to err on the side that it applies to all auto-dialed messages. But there's ways of, kind of channeling people into, if they want to opt out of all marketing communications, you tell them this is how you do it. But if you do it that way, you make it clear that you're not opting out of, kind of informational, a cadence for the current semester. So again, it would be context specific, but if it's, if they say stop and there's no limiting, I would treat that they're opting out of all auto-dialed communications.
Okay. Next question up is motor vehicle dealers in many states have closed their showrooms, but customers are visiting websites and negotiating deals via text messages with a salesperson who is using their personal cellular device. What processes can be put in place to protect the dealership and also the individual salesperson from potential TCPA violations?
It's a broad question. So I would assume that, one, if they're texting from their personal device, the agents, they're not auto dialing. The whole kind of I could talk at length. It would be another webinar about the history of auto dialing. But essentially, the DC Circuit overturned the FCC's just incredibly broad reading of what's an auto dialer, and one of their express grounds was that the FCC's 2015 TCPA order would turn any smartphone into an auto dialer. And so on those express grounds that their interpretation would have swept in, just normal phones being auto dialers, it's fairly safe that, you're not using an auto dialer by texting someone from your smartphone. That's just not the type of equipment that, certainly was meant to be swept into the TCPA. So then the real issue then becomes that you are still engaging in potentially in, kind of telemarketing. You can still telemarket and be subject to TCPA even though you're not using an auto dialer. And so what that means then is because, as I said at the top or earlier in the webinar, that there's this subsection C, which relates to do not call rules. And so that's kind of the catch-all that even if you're not using an auto dialer, you still need to be mindful of just telemarketing in general for any and through any technology. And so what you need to be mindful of there is you need a do not call policy in place. You need to train your employees. If someone says don't call me, don't call them. It's pretty easy. But you're really talking about a paragraph or two internally, because how these kind of suits develop is that the policy actually has to be per the FCC's rules. It says the policy needs to be available on demand. So if some consumer says, I want to see your do not call policy, you have to be able to, within a short amount of time, present them your do not call policy. Again, a lot of arguments why, someone's not actually injured if you don't have one. But it's just, if you can get a 2-paragraph policy in place, you can just save yourself some headaches down the road. But then, so that's the one way I would address that, just from a basic compliance perspective. But then you also want to, just think about the terms and conditions that can really save you. Just have if you're a dealership where you're somehow, doing a click to call, honestly, there's going to be some great arguments that if the consumer is reaching out to you looking for information on a particular model, at least that first call, if you're responding back to them, that's an informational message by most readings in the case law, that if the consumer says, I want information on X car, and you send it back to them, even though you're obviously doing it to hopefully get a sale, you're just providing the information the consumer wanted. But really where the telemarketing then comes into play is downstream, where that first conversation ends, and then you start pinging the consumer, hey, are you still interested in car X? So the bottom line is that if you have a channel on your dealership website where they click through, that's where you want to get the terms and conditions in place, that you present it to them. They have to affirmatively click through them. It doesn't have to be, yes, I agree to these terms of service, but it can be something as terms apply, and you have a hyperlink where you have the class action waivers, arbitration provision, because that's going to be a poison pill for the TCPA plaintiffs bar. So that's how I would address that situation.
Okay. Next question is, if someone is opted out of phone and text communications, can we still contact them through the same channels for debt collection? And is there a difference between one-on-one versus an autodialer?
Addressing the first one, or the last one first, yes, there's P2P is not an autodialer, assuming there's not some hidden capacity to autodial behind it. So there's not going to be the consent requirement for P2P. So that, I want to state that at the outset. But then for debt collection, that's an informational call. So assuming you are not using an autodialer to collect on a debt, under the TCPA, you're not restricted if you're using P2P, and there's no sort of hidden capacity to be an autodialer in that service. So again, this is where the first part of the question was, can you still text them if they've opted out? This really goes into the don't shoot yourself in the foot category, where if they opt out, you just make it clear to them through terms and conditions or otherwise, where if you're opting out, it's going to be you're opting out of the mass texting, or you're clearly delineating that the opt-out is applicable to kind of not non P2P communications. It's going to be any type of autodial communications. So you just want to make that clear to the person, and then you could always point them if there's a later dispute, saying, hey, you signed these terms, you agreed to these terms. The terms clearly state that if you opt out of this, you're not giving away our right to contact you through other non-autodial means. So that's how I would address that situation.
We have a customer who says, we're using your services and we're placing a keyword ad for respondents to text in and get a link to provide a Zoom meeting link back. Do they have to be opted in before the dialogue can continue? So I think this is a recruiter, and he's using it for job posting. So he's trying to get people interested in a job. They text in the keyword job to get a link back for a Zoom meeting. He's wanting to know is that initial text in enough consent, or does there need to be further consent to have an ongoing dialogue for one-to-one communications?
Yeah, that's a good question. So I would assume if you're just providing them the link for a Zoom meeting for an initial screening, that's fine. And then I guess my question would be how the term or the relationship is structured. It kind of goes into, I had a case where it was kind of, premise was that you were like a real estate broker, and you were trying to get agents to list through you. Essentially, you were offering them employment. And so what the upshot was, that's not telemarketing. If you are trying to help someone, if you are not getting paid by the recipient of the message, if you're not encouraging them to purchase a product, good, or service, I would say, again, I with the disclaimer that this is not specific legal advice without knowing all the facts, I would say I would be relatively confident that if you're just trying to help someone find a job and they're not paying you for that, you would be in informational land. And then therefore the prospective job applicant's voluntary release of their telephone number is consent for not only that single text, but any ongoing type of points about that.
Okay, we've got roughly 6 minutes left here, and we've got two questions. So We've got one user that says we're a public university and have students that have applied but need to confirm enrollment, and the deadline has been extended to X date. We're not sending a link, but we want to inform or remind them of the deadline and offer to answer any questions. And the main thing here is that I think she wants to know is what level of consent is required. Is that considered, if it's an applicant, is that considered marketing, or is that informational?
I'm fairly confident, so again, if this is someone who has applied and they haven't expressed, essentially there's case law and the FCC's binding orders that essentially say that if you are in the process of negotiating agreement that the consumer has expressed an interest in, and you really, like the touch points are about the application they've already submitted or are in the process of negotiating, then those types of communications are viewed as informational. And so, again, you kind of always want to be on the safe side, that you have terms and conditions that this is how you could address in advance and nip that litigation risk in the bud. That you're since we're basically you'd be defining the battlefield beforehand, where you kind of have terms and conditions where the prospective student through a click-through link is agreeing that you can contact them through any type of technological means, to including autodialers, to contact them about deadlines, anything related to their application that they're expressing interest in. But that's kind of what I would recommend, the gold standard. But as a basic legal premise, I would say you are safe to alert people to deadlines if they have in fact submitted an application. Whether it's P2P or through an autodialer.
Okay. Last question here. If you've got one more, we might be able to get one more in here. But the last question on Q&A is, if a user opts out of a marketing campaign via a shortcode, does that apply to our other shortcodes as well? What about long codes or one-to-one texting?
So the opt-out will be seller specific. What that means is that if you have shortcodes, for multiple shortcodes for any reason, you can't just start texting them from another one and evade the opt-out that way, unless there are specific programs or reasons why you have different shortcodes and your opt-in language was fairly specific that, hey, we're going to text you from here for these types of text, and we're going to text you from here for these other types. And you have to opt out separately. So if you have that language, you can presumably go in. But if you don't have that qualifying language that you put the person on notice that they need to opt out separately, I would just do a universal opt out for that person.
So let's just say that this is a travel company, and they've got promotions that are marketing some of their travel or destination marketing, and then they've got a separate shortcode that is doing alerts for customer service.
So if it's customer service, and then you get into informational text,
right.
It gets a little gray, because again, this is where you can relatively easily define the battlefield, because you tell people in terms, when you opt out of this, you're only going to opt out of promotional marketing messages. You're not opting out of customer service communiques about an existing trip, for instance. So that's where you want to just define it, because some people may have an arguably reasonable expectation that by texting stop, they're going to stop all communications. What you could conceivably do if you're in a bind because you don't have terms of service is you would set up a double opt-out process where you could do stop, and then you would basically say in response, you've been opted out of all promotional communications from company X. If you'd like to opt out of all informational communications about your currently scheduled trip, reply stop all. So you would put it on the consumer that way, that they need to take a further step And so I think that would be a fairly reasonable put the baby approach if you're in a bind without, kind of terms of service in advance, kind of that explain that to the consumer.
Okay, so that concludes our webinar for today. I really appreciate Adam for joining us and sharing his insights around TCPA. And thank you guys for joining. If you have any questions or you want to learn more about text messaging or voice messaging solutions, please check out True Dialogue and our sister company VoiceShot. And if you have any more questions around TCPA, feel free to check out Errant Fox or contact Adam directly. Thank you, everyone. Have a great day.